Very good evening, students. Please confirm about the voice and the video. I'll start the session within 2 minutes. Okay, very good evening, Aprajita. Very good evening, Divya. Very good evening, Sulekha. Okay, perfect. Okay, students. So let's start this class now. I welcome each one of you to my YouTube session on the Specific Relief Act 1963. Let's start with my brief introduction first. My name is Sandeep Khatri. I've done my law from University of Mumbai and my LLM from Jindal Global Law School. By profession, I'm a teacher. I'm teaching law for more than 5 years now. My areas of specializations are the constitutional law, criminal law, commercial law, family law, and law of torts. This is the link of my profile, which you can see on the screen. My link of profile on Unacademy, which you can follow to get all the updates about my special classes and plus courses. This is my Telegram channel where you can connect with me to ask queries related to your judicial preparation. In addition to that, I have also mentioned my code, that is KHATRILIVE, KHATRILIVE, which you can use to get free access of all the special classes available on Unacademy. In addition to that, you can use the same code to get 10% discount for all your plus courses as well. This was about me. So now I request everyone, please be attentive. This is going to be an interactive session, which means anything, if it is not clear to you, you can write your question in the comments and I'll answer accordingly. So what we are going to discuss in this session, this is going to be a Q&A session on the Specific Relief Act 1963. So anything from the Specific Relief Act, starting from the basics till your section 44, anything which is not clear to you, this is your time to ask questions. One more important announcement, students. Tomorrow I'm going to conclude this subject at the same time from 7 to 8. I'm going to conclude the subject with the help of MCQs. So this is your time to ask questions, get answers for all your queries related to Specific Relief Act, and tomorrow I'm going to ask MCQ. Tomorrow there is going to be a complete test of PT test on this subject. Okay, so I hope I'm clear with everything. So now this is your time to ask questions in the comments and I'll answer one by one. Yes, students, please. Without wasting a second, yes, questions please. Okay, Prajita, I still remember that you are asking about a section, that is section 41, right? So I will start with section 41 only. Anything else? Anything else other than section 41 which is not clear to you? Yes, Aprajita, that is section 41, so I'll explain that. One more thing, I'm also working on a creative chart of Specific Relief Act where I can, sum up all the sections involved, all the concept involved in Specific Relief Act into one chart. So it is taking some time. So probably in the next class or maximum by the day after tomorrow, I'm going to reveal that chart as well on Specific Relief Act. Okay. Yes, anything else, students? Yes, Aprajita, I'll start with 41. Yes, what about any? Okay. Okay, students, then I'm starting with section 41. Be ready with your questions, students. Because after 41, I'm going to again ask you only that what problems do you have from this subject. So I'm starting with now 41. Section 41. First, you need to understand that this section is important for your PT as well as your for mains examination as well. Okay, you usually get direct questions from this section number. Okay, so a list has been given under this section, a list of 11 points, which I'm going to discuss all one by one. All those 11 points discuss about when injunction may be refused. Okay, when injunction will not be granted, what are those situations? So there are 11 situations, 11 circumstances that has been mentioned under section 41. So let's start with one by one. The first one students, the first one is related to judicial proceedings. I'm writing in the short form here, judicial proceedings, which means if one party want to go to the court, that party cannot be restrained with the help of injunction. Let's take a simple example here. If suppose there is a contract between Mr. A and Mr. B, and Mr. B committed breach of contract. Now Mr. B cannot go into the court and in the suit ask for an injunction that Mr. A should not go for any judicial proceedings. That is not allowed. That is your first point, students. There is one exception as well of this first point, that unless to prevent multiplicity of proceedings, in that cases that may be allowed, but usually it is not. General rule is that you cannot stop someone for the judicial proceedings. Next, second point is, students, which is again related to judicial proceedings, but that is for not subordinate court, which means when you filed a suit, Mr. A has filed a suit in a court, and suppose if the jurisdiction can be of high court as well and district court as well, okay, and then if the person is filing for injunction in high court, then that you cannot restrict that same person to file a suit, to go for injunction in the high court. Why? Because that person can go for superior court as well and the higher court as well. So that is your second point. Coming to the third one is related to legislative body, which means you cannot again restrict. See, all these injunctions started with to restrain. So matlab injunction cannot be filed to restrain from doing all these things. And in the third point is your legislative body, and here legislative body means any kind of municipal commission, like municipal commissioner. So again, you cannot restrict someone to do that. Fourth one is very, very interesting. Fourth one is talking about, students, that there are cases which fall in civil as well, which fall in criminal as well. And if suppose civil suit is going on that breach, for example, negotiable instrument falls under that. So in that case, if that is the case, section 138 of negotiable instrument, so in that scenario, if there is a civil suit that is going on right now and one party wants to move criminal as well, so that party cannot be restricted for only civil suits. That is always the discretion of the party whether they want to go into only civil or both the cases. So that is your fourth one. Fifth one, that is E. This is important, students. Very good evening, everyone. Aparajita, mind it, trespass is only civil. There is a lot of confusion on trespass and nuisance. I'm repeating myself. When it comes to nuisance, private nuisance will fall under law of torts. Public nuisance is an offense. 268 of IPC. Similarly, trespass is your tort, but criminal trespass is an offense. Clear? There is a difference between these two concepts. Now, continuing with the fifth one, this is important, students. We will go into the detail of this one. Let's take one example. If there is a contract between A and B, and A has committed a breach of contract. Everyone please be attentive, this is important. I am explaining E right now. Section 41 E. If there is a contract between A and B and A has committed a breach of contract, but the contract is of such a nature that Mr. B cannot file a suit for specific performance, that is not allowed. Why? Because of section 14 maybe. Let's take an example of section 14, which means no specific performance is allowed. So let's take an example. This was because of singing. Okay, the contract was of singing. Okay, or of teaching, or of painting. So these all are related to your personal qualifications. So in case if Mr. A is a singer or a painter or a teacher, these all deals with personal qualifications. In those situations, mind it students, in those situations, suit for specific performance cannot be filed by Mr. B. And if Mr. B cannot file a suit for specific performance, similarly, he cannot go for injunctions as well. Injunctions will also be not allowed for that case. I hope everyone is clear. Now I am going to come on this exception of E as well, which is your section 42. But first, just clarify if you are clear with 41E. Yes. Yes, any questions till section 41E? Very good evening, Manisha. I hope everyone is clear with this one. Okay. Okay, perfect. Now I am coming to students. Now I am coming to, is there any exception of this? The answer is yes. The exception is section 42. Now the question is how section 42 is an exception of this. Section 42 says that, let's take an example now of 42, and after that I will continue with 41 only. 42 says, suppose there is a contract between A and B, and the contract is such that A is going to paint. A is going to paint for Mr. B only. For Mr. B only. First and second point of the contract is that Mr. A cannot paint for someone else. Cannot paint for someone else. And suppose the duration of this contract is 1 year. Okay. Now this was the contract between A and B, that Mr. A has promised that he will paint exclusively for Mr. B, and second point, he will not paint for someone else for a period of 1 year. And in consideration, obviously Mr. B is going to pay Mr. A. Now this contract was for 1 year. Now let's assume for first 3 months everything goes fine. No issues at all. Now in the fourth month, Mr. A committed breach of contract. Mr. A committed breach of contract. Now, first question, students, can B go for specific performance? Answer in the comments. Can B go for specific performance in this case? Answer in the comments. I have already told you this. Yes. Waiting for your answer in the comments. Yes or no? First one to answer, Prashant. No. Okay. What about others? Students, I told you this is going to be an interactive session. Even if you don't know the answer, just write don't know so that I get to know about this. And I'll explain in that way only. Okay. I've got no from Aprajita. Mosmi is saying yes, can. So now I'm concluding this, students. The answer is no. The answer is no. Mosmi, reason for this, section number 14, clause C, okay, because this involves something which is personal qualification, okay, that is why no specific performance. And if no specific performance, section 41 clause E, what section 41 clause E says? E says no injunction as well. But now we are going to read exception. Exception is section 42 says that when there is a contract, of positive assertion and negative assertion. What is positive? Positive is to paint. What is negative? That you will not paint for anyone else. Now section 42 is saying that as far as positive assertion is concerned, which means as far as this painting is concerned for Mr. B, there is no specific performance. But as far as this thing is concerned, I'm using another color for this, the blue one. Negative assertion. As far as this negative assertion is concerned, in that case, yes. In that case, yes. Injunction can be granted for this. Injunction can be granted for this. Fine. Which means B can stop A to paint for someone else for the period of 1 year as per to the contract. The only condition attached to that is that Mr. B have to pay the amount agreed as per to the contract. That's it. Any issues with section 42? Anything which is not clear to you related to 41E, read with section 42. Are we clear? Okay, Aprajita. If you are not clear, I'll repeat myself. See, section 42 is saying if there is a positive assertion in a contract. Now, in my example, what was the positive assertion? That Mr. A will paint for Mr. B exclusively. That was the positive assertion, right? So section 42 is saying that no injunction can be filed against that, which means B cannot force A to paint exclusively for Mr. B. That is not allowed. But as far as this negative assertion is concerned, what was the negative assertion as per to section 42? The negative assertion was that Mr. A can be stopped for painting for someone else for the period of 1 year. In that case, yes, injunction is allowed. 1 year is the time period of the contract. 1 year is not the limitation period here, Mosmi. 1 year is the time period of the contract. Okay. So now 3 months तो वो सही पहले से ही चला था. Now for these rest of the months, okay, for rest of the 9 months, he can be stopped. I hope I'm clear. Okay, I've got all the thumbs ups, which means you all are clear with this. Now I'm continuing with this. 41, come back. 41F says to prevent any ground of nuisance which is not nuisance. That is also the case. Second, G1 is to prevent a continuing breach. Students, always do remember, if a person is sleeping over his rights, the court is not going to wake up. If someone has already waived off his rights, in that case, you cannot go for injunctions anymore. Okay. Next one. If there is any alternative effective remedy already available, so better you go for that alternative remedy and not for injunction. This is your H. HA is basically a repetition of section 20A. HA is basically the repetition of section 20A, which says when it comes to infrastructure projects, no injunction shall be granted. Then I is the one, if you must have read that maxim that the person, if you are going into the court, you must go with the clean hands. It should not be like this, that I am the one who is doing the wrong things and then I am the one who is moving to the court first for taking the injunction. So that is also not allowed as per to I. And the last one is, if the plaintiff has no personal interest, then he is not allowed to file injunction. Yes, now anything which is not clear to you. Very good evening, Sapna. Aprajita sir means if there are both positive and negative in the same contract, we have to enforce both. Aprajita, I'm concluding this. If in In a contract only, there are both positive assertion and negative assertion. For negative assertion, you can go for injunction. For positive, no, you are not allowed. Why not allowed? Because of section 41 clause E, because of section 14 clause C. Okay, these are the two reasons. And why negative assertion is allowed? Because of section 42. That's why I said that 42 is the exception of section 41E. Yes, he who seeks equity must do equity. This maxim will fall under I, 41I. Yes, students, anything which is not still clear to you related to 41 or 42 or anything about Specific Relief Act. Yes, those of you who have just joined, I have already announced that tomorrow I am going to take a test on Specific Relief Act, combining all the sections, MCQ test. So make sure any doubts if you have right now, this is your time to ask questions. Okay, you're welcome, Aprajita. Yes, students, anything else? Anything else? Yes, Manisha, only vigilant. 41G. Okay, let me give you one example of 41G, Aprajita. Listen carefully. If suppose this is the house of Mr. A, okay, and just assume that the land of this land is also belongs to A, and A made his house this much, but now the land which owned by Mr. A, people are using it as an easement right, and Mr. A is saying nothing about this, and this is for years in the sense this is a continuing breach. Okay, and if this is a continuing breach and later on Mr. A comes with a against those person ki please give me an injunction so that no one should cross from this area or over this land, he is not going to allow that. That is your 41G. Anything else, students? Yes. Okay, Prashant is asking about section 23. Okay, Aprajita, can we move to section 23 now? Or you still have any doubts? Okay. Maximum delayed fees justice. Yes, Mosmi, we can say that as well. Just okay, let me confirm maximum G now. Yes, you can use that maximum, Mosmi. Okay, now I'm starting with 23 and I'm first giving you an example so that you can easily understand section 23, the essence of section 23. There are two parties, Mr. A and Mr. B, and they are having a contract. And in this contract only, they have mentioned one clause. And what is that clause? That whosoever is going to commit the breach of the contract, that party have to pay 50,000 rupees. Which means that if A is going to breach this contract, A will give 50,000 to B, or if B is going to breach the contract, Mr. B will give 50,000 to Mr. A. Fine. Now in that scenario, if that is the case and Mr. B suppose committed breach of contract, and now Mr. B is ready to pay 50,000. Now Mr. B is ready to pay 50,000 as per to the contract. Now the question here is, can A can A go for specific performance? Answer. Or if I need to reframe this question in terms of section 23, will this 50,000 rupees bar specific performance for Mr. A? Yes. The question is same. Anyone likes to answer this before I conclude this topic? And the answer is, students, okay, let me wait for 1 minute. Let me see if you can easily answer. You can read the heading of section 23 as well, which says liquidation of damages, not a bar to specific performance. Not a bar, which means the answer is no. The answer is no. A can still go for specific performance unless and until it has been barred by any other express provision. That's it. Prashant and Mosami, please read the heading of section 23, which says liquidation of damages. Liquidation of damages, not a bar to specific performance. Okay. Yes, Aprajita, they can go for specific performance. The only purpose of putting liquidation of damages in the contract was so that they will not commit a breach of contract and only go for performance of the contract. That is your section 23. Now, anything else, students? Anything else? Okay, Prashant is clear now. Yes, students, questions, problems? All clear? And if you don't have any questions, so then I'll ask mine. Okay, Manisha. Yes, students, questions? Any section which you are not clear with? Aprajita, section 21 and 22. Okay. So I'm explaining section 21, students. 21 is basically power to award compensation. Okay, there are certain cases in which the court got the power under section 21 where they can award compensation. Now coming to what are those cases. Always do remember when okay, let's take an example here also. A and B are having a contract. Okay. And as per to this contract, Mr. B is the one who has committed a breach of contract. Now, Mr. A has filed a suit for specific performance against Mr. B. Right? In this situation, can court, okay, if Mr. A claim ki okay, I want specific performance and in addition to this I want compensation as well from B, so the court has power as per to section 21 to award him compensation in addition to, students, this is important to remember for your exams. As per to section 21, you are giving compensation in addition to what? Specific performance plus compensation. As per to section 21 clause 1. This is your 21 clause 1. Okay, moving to the next one, 21 clause 2. Let's assume in that case, in this similar case, I'm continuing with this, specific performance was not given by the court. Then court may still give compensation as per to section 21 clause 2. Now coming to the third one, there might be chances that specific performance has been given, but the court feels that for the sake of justice, to do complete justice with the parties, there should be compensation as well. So again, as per to section 21 clause 3, the compensation can be awarded. Okay. Now clause 4 talks about that how you are going to calculate the compensation. So that is as per to section 73 of the Indian Contract Act. This is as per to the section 73 of the Indian Contract Act. Okay. And no compensation as per to clause 5, no compensation should be awarded to the plaintiff unless and until that plaintiff has already asked about that compensation in the plaint. That's it. That is your 21. Any questions? Any questions, students? From 21. Yes, Aprajita, are we done with 21? Or still if you have any questions? Waiting for your confirmation so that I can move to the next query, which is of section 22. Okay, I'm moving to section 22 now. Okay, perfect. Now students, listen to this. If there is a contract between, I'm taking one simple example so that you can easily understand the concept. Okay. So suppose there are two parties, Mr. A and Mr. B, and there is a contract between them. And the contract is related to transfer of immovable property. Fine. Now, in that scenario, if suppose Mr. A has committed breach of contract, now Mr. B can claim specific performance, and while Mr. B is claiming specific performance against this contract, against Mr. A, what else Mr. B can claim? So he may claim possession as well, or partition or separate possession of the property addition to such performance. I hope I'm clear. Let me make a different graph here. In this specific performance, in addition to this specific performance of the transfer of immovable property, Mr. B can also ask for possession of this property, or as per to the case, if it is a case of partition, then partition and then possession of the property. That again depends upon the facts of the case. Okay. The reason why do we need this concept? How this is going to help us? How this is going to help us? The reason is very simple, so that Mr. B, if got specific performance of this contract, then he needs not to file a separate suit for the possession. So to avoid multiplicity of proceedings, it is important that we give this power to party to take the possession here only in this case. Okay. Yes, any issues with this? It's okay, Amit. It's okay. It's okay. Aprajita, I'm coming on that. Okay. Now let me give you this example. One more example on this, students. Just give me a second. Okay, now I'm giving you one more example. Mr. A, Mr. B, and there is a contract between them, and the contract is of transfer of immovable property. Okay. And here A is the one who is selling property to B, and A has committed breach of contract. Everyone please be attentive. I'm concluding this. Mr. A and Mr. B are having a contract between them, and contract is related to transfer of immovable property, and A is the one who is selling the property. And just assume that A is the one who has committed breach of contract. And if A has committed breach of contract, what B will do? B will file for specific performance against A. But in that case, the specific performance, it is the discretion of the court. So if the court declined it, which means no specific performance. Now, if no specific performance of this contract, what if Mr. B has given some money in advance to buy this property? That money plus the earnest money. Earnest money is, let me give you an example. If suppose there is a C where Mr. B has submitted some amount. Mr. B has submitted some amount to Mr. C. This is basically kind of your escrow account, okay? Which means you submit your money with the third party. Which means if all things went well, this money will went to A. But because there was a breach of contract and now there is no specific performance as well, this money which was given to Mr. C, the third party, this will go back to Mr. B. In addition to that, if there is any money that has been given by Mr. B to Mr. A, that money will also be returned to Mr. B. I hope I'm clear with this now. Aprajita, done? And still, if you have any questions related to 21 or 22, ask questions in the comments. Or any section of the specific relief act which you think you are not clear with or you find it difficult to understand, this is your time to ask questions. Yes, return करना पड़ेगा मनीषा. Okay, Prashant is clear. Aprajita, waiting for your answer. Okay, clear? Done. So that was your basically 22. टोकन के लिए जो पैसे दिए जाते हैं, yes, उनको in layman language we call that token money as well. Because see, if you are not selling your property, so at least you have whatever amount you have taken from B or whatever amount that has been submitted to Mr. C, third party, for the smooth transaction, that all money will go back to Mr. B. That's it. Yes, students, anything else? Tomorrow you are going to have a test on specific performance, MCQ test. So make sure that you will not commit any mistake. Anything else? Aprajita, Prashant, Manisha, Amit, any questions from Specific Relief Act? Any section which is not clear to you? Waiting for your questions in the comments. Section 25, what conveying? Okay, I'll conclude section 25 in a very simple language, students. Section 25 is basically saying that the provisions of this chapter, which is basically section 9 till section 24, all these concepts of section 9 till 24 shall apply. ये किस पर apply होंगे? Arbitration, आर्बिट्रेशन पे जितनी भी आपकी सेटलमेंट्स होंगी आर्बिट्रेशन के थ्रू उन पर अप्लाई होगा, विल पे अप्लाई होगा और कोडिसल. That's it. This is your section 25 students. Okay. मनीषा आईपीसी का भी टेस्ट है कल एट 2 और स्पेसिफिक रिलीफ एक्ट का. ओके इट्स ओके अमित. See, I'm going to give you the essence of Prashant, section 33. Section 33 says, if there is one instrument, so let's take an example, if there is any contract and A and B has entered into that contract, fine. Now obviously some things that A will get as per to this contract, some things that B will get as per to this contract. And while this contract was taking place, there may be chances A has got possession of the property and Mr. B has taken some money because of this instrument, because of this contract I am taking about. Contract is a specific term, instrument is a wide term. Anything, any document can come and fall under the definition of instrument. Now suppose as per to section 31, if this document got cancelled, in this situation, this possession, let me use another color, this possession students will go back to Mr. B and this money will go back to Mr. A, which means restoring the parties in the same way that was before the contract. Whatever the situation was there before the contract, that situation we will employ. Yes, anything else? Yes, students. Waiting for your questions. Aprajita, I will see. I just told you that I'm working on that smart chart. In that smart chart only I will try to include case laws as well, a list of cases. So I will take one full class on that, in which I'm going to tell you the charts, how to learn the sections, how to conclude all the topics, and in addition to that case laws as well. Case laws are not much, but yes, I'm trying to pick at least 8 to 10 case laws on specific relief act, which will help you to write answers in the mains. Most probably this class which I'm talking about right now will take place day after tomorrow. Okay, because once I'm done with your MCQ test, then in the next class I'm going to talk about this smart charts, that how can you remember and conclude everything in one chart. Okay, anything else? Aprajita or anyone? Okay, so are we done here? No questions, no problems at all? Wonderful. Okay, then I am concluding the class, students. So this is my profile on Unacademy, and from tomorrow onwards I am going to start with a new subject, students, that is Indian Evidence Act 1872. You can find the link of the course in my on my Telegram channel as well, and in this profile as well. Okay, So this is my code KHATRILIVE, which you can use to get free access of all the special classes which are available on Unacademy app. So use that, okay? So let's crack PCSJ with Unacademy. You can use this code KHATRILIVE for 10% off. Compete with thousands of aspirants and stand out from the crowd. Free special classes every day. You will get all the classes, students, on major subjects, minor subjects, local laws, GK, current affairs. All classes are available on Unacademy. These are some special classes features: that interactive live classes, poll for learners, plus subscribers can raise their hand and can actually speak with the educator as well. You will get all the notifications, so you will not miss any of the classes. You will get lecture notes and you can access it anytime, anywhere. India's best educators are available for you. These all are the courses which are going on right now, students. So once you are a subscriber, you can attend all these classes. This is the pricing plan and the plus subscription. More the months, less the price. The idea is that, and you can see, you use the code KHATRILIVE for 10% off. Price hike is coming soon, students. So if you are planning to subscribe, make sure you do that before 23rd September because there's a 10% price hike going on. These are the YouTube and Telegram channels of Unacademy, where you will get all the updates about all the educators and the upcoming courses. Thank you. Like, share and subscribe. If you think that this class helped you in any way, please do like and share it with your friends and subscribe to this channel. It's okay, Amit, you can watch the recorded. Prajita 28, 29 and 30. Aprajita, I guess it's already the time, so I will take your question in the next class. Okay? Don't worry, I'll answer you. Fine? Okay, students. So on that note, thank you very much. See you in my next class. Till then, peace.